Good afternoon, convening our House Investigative Committee. Today is Monday, November 29th, 2021 for our 1 p.m. hearing in person and via video conference here in conference room 325 of the state capitol. I want to thank everyone for being here, for coming to this place of business on the weekend after Thanksgiving, and for continuing to do the work of this committee. By way of our agenda, we're going to be taking up first the testimony of Mr. Christopher Ewan, board member for the Board of Land and Natural Resources. Members will be taking questions, and then we'll follow that with a 2 to 3 minute break. And then Mr. Char will be up next as a second board member. Again, another hour and a half of questionings. Our goal is to be done with the formal taking of testimony by 4 o'clock, and then members, we will have to deal with some procedural matters at the end. So the goal is to be done by 4:15, 4:30 p.m. With that said, we're here today first with Mr. Christopher Ewan, board member of the Board of Land and Natural Resources, who is coming to us via the Big Island via Zoom. Mr. Ewan, can you hear me?
Yes, I can.
Thank you for joining us. So because this is a Chapter 21 hearing, I have to swear you in first. And what that means is that you have certain rights. As a Chapter 21 witness, you'll be able to provide questions to any other witnesses we may have coming forward, as well as review our findings and draft recommendations and submit any written responses to those findings and draft recommendations, or those recommendations when we finalize the report. Do you have any questions about that?
No, I don't. Thank you.
And you do have your attorney here present, Ms. Melissa Goldman, here in the room. So if you should need any questions or take a pause, or Ms. Goldman, please just interrupt as needed. But I'm hoping that we will have a seamless interview or hearing. So with that, Mr. Ewan, you don't have to stand up, but I do need to swear you in. So if you could raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
For the record, Mr. Ewan has stated yes, that he affirms to this oath. So Mr. Ewan, thank you so much both for your service, just generally. You have a long career in public service, and especially for your service on the Board of Land and Natural Resources. I wanted to first start off by allowing you to provide a little bit of a self-introduction. Please provide this committee with any of your background, especially as relevant to being a board member of the Board of Land and Natural Resources. Go ahead.
Well, I was born and raised near Hilo on the Big Island, attended school here, went away to college, went to Stanford and University, and eventually got a master's degree in environmental science. I was involved a lot in environmental issues on the Big Island, particularly land use issues, starting with, in 1971, a public campaign that eventually led to establishment of Carl Smith's and Richardson's beach parks in Hilo. I was very involved in the movement to save Makalavena and Awakee in the late 1980s, and was able to continue working on that on the board in the 1990s, leading up to the Keikahakai State Park, worked with communities in Kalapana and elsewhere on threats to their communities. In 1990, I skipped something here. I went to William Richardson's law school and got a law degree in 1982, and worked for County of Hawaii for a while as a deputy corporation counsel, and then went into private law practice. In 1990, I was appointed to be the Big Island member of the Board of Land and Natural Resources by Governor Waihee, and reappointed to a second term and served until 1998. In November 2000, I was appointed planning director of Hawaii County by Mayor Harry Kim and served for 2 terms under Mayor Kim until December 2008. And after that, I never did really reopen my law practice, and I've been mostly working as a farmer. I have a certified organic farm here, about 18 miles north of Hilo, grow lychees, rambutans, and bananas. And in 2014, I was appointed to an at-large seat on the Board of Land and Natural Resources by Governor Abercrombie, and later appointed to another term by Governor Ige. And my current service will end June 30th, 2020. I've been serving since July 2014.
Thank you, Mr. Ewan. And I find it very interesting that you've actually served on the board under 3 different governors. And so that will provide, I think, an interesting perspective for the committee to understand. Before we continue, just from our communications with the auditor, my understanding is you were not quoted in the report. Do you recall being interviewed by the auditor as part of the audit while in your second term in 2018?
You know, when you asked me this question at our informal meeting, I didn't remember. And then I realized, yes, I was. I'm sure I was. But I don't, as far as the quotes in the audit report, some of those you can tell are from other people because of other identifying information that they've given. I don't recognize any of the other quotes as actually having come from me.
Okay, that's interesting. You know, we had asked members, and I don't recall if do you recall if you were recorded as part of that interview?
I don't.
Okay, if you were, would you be open to signing a consent form for us to receive the recordings of any interviews? I understand that other board members had done that, and you don't need to answer that now, but maybe we can do that as a follow-up. I know we have consents on the record from other members who were interviewed as part of the audit.
I'd be fine to sign that. There's no problem with that. I'd be interested to see what I had to say myself, because I'm sorry, I really don't remember anything about it. But I realized that when I looked at the report, I said to myself something like, "Oh, this wasn't me that they're quoting," and I wouldn't have thought that if I hadn't been interviewed. I would have just thought, well, you know, I wasn't even interviewed.
Okay, thank you, Mr. Yuen. So we'll follow up with you and Ms. Goldman about that consent form. So before we delve into the topic areas that were highlighted in the audit report, I did want to ask you, given your wide experience both in government practice and then the fact that you had served actually in a term previously in the 1990s and then under two different other governors in the period between 2014 through the present, were there any big takeaways or impressions that you had about the audit report when it was provided to you as board members and disseminated widely as the public? Any big takeaways or impressions you had?
Well, you expect this kind of report from the legislative auditor to be somewhat critical. And I think it's, you try not to respond defensively at the outset, because very often, you have somebody from outside your organization looking, and perhaps they do have suggestions for improvement and things that you should, the things that are valid. I do have to say, though, that on the whole, I felt that the department's responses to the report were much more convincing than the audit report itself. And I had a few things in particular where I thought that the auditor missed the mark, some rather important things.
Would you be willing to share that with us now, what those big marks that were missed?
Well, the first was a big focus of the audit report was criticizing the BLNR's extension of leases in the Kaneohe area on the Big Island in Hilo. And basically, they said that the BLNR, the state could have made more money if we had let those leases expire and release them out, because at the end of the expiration of leases, the buildings belong to the state, and then you would lease the land with the buildings, whereas the lease rents in the terms that are existing are simply based on the land. I think that this ignores the fact that the board and the department implement legislation, and there was legislation which authorized these lease extensions. Now, it's true that it did not mandate the lease extensions, but it's also true that in most cases, you could make more money by letting the lease expire and leasing it out with a building. The exception would be if the building was so run down that you had to tear it down, and then of course you would, in a way, you'd rather let the lease be extended if they improve the building, but if we took that as the reason for not extending the leases, we would simply we would not implement the legislation. We wouldn't extend any of these leases. So that's one case where I think that the department and the board are basically implementing legislative policy. And from the department's point of view, initially they did. The first lease that came for renewal in late 2012, the department recommendation was not to renew it because they were going to they wanted to consolidate and re-subdivide certain properties in Kanalehua. And the board, and voted to renew the lease unanimously. And by the time I came on the board, about a year and a half later, several leases had been renewed on this basis, and this was clearly the policy, practice, and the pattern. The other aspect, though, that I think then the auditor says we could have made substantially more money and by leasing it with the buildings. But if the idea was to consolidate and re-subdivide, then you're going to tear down the buildings. And in fact, some of the ones in particular that came up were this idea of those consolidation or re-subdivision. So you might make more leasing the land once it's been consolidated and re-subdivided to a better size. But you'd be leasing it as raw land again. You wouldn't be leasing out the building. So there are a couple of other things. I don't know how much you want me to get into the specifics of criticisms that I have of the audit report.
Maybe we can come and circle back to that towards the end of questioning if that still remains as questions. But maybe we should open it up now. So to the members for questions. And I just want to remind members that the areas of concern, the board, the audit made specific recommendations for the board regarding training, development of long-range asset management and strategic planning, and reconsideration of the caps on annual rental readjustment. So those are the specific recommendations made by the audit report. We can be constrained to those or also ask questions in any of the other areas that have been raised in the course of our hearings. So with that background and context, I'm going to first turn to Chair Tarnas for the first question for Board Member Ewan.
Thank you, Chair, and thank you, Mr. Ewan, for being with us today, and thanks for your service. I wanted to follow up on the criticism from the auditor about the lack of a strategic plan and marketing plan for our state lands that are to be leased. Could you give us your perspective on that? I mean, there's a lot of land in the portfolio. How would you suggest would be the most efficient way for the land division to move forward on a strategic plan and a marketing plan to basically make a successful effort to lease these lands?
Well, apart from trying to do a good job on the properties that you already have for commercial and industrial leases, at some point the department or the land division did come up with Pulehunui on Maui and East Kapolei on Oahu as the best sites for the state to expand its commercial and industrial land leasing program. And I'm not sure what the thought process was for that, but I think it was, I'm going to trust that it was done and that they came up with these sites and now they're pursuing them. So if you're looking at specific areas, that's what the division came up with. And if you look at major major landowners in Hawaii, Bishop Estate, for example, they make the vast majority of their income from relatively few properties in relatively few areas that have a lot of economic potential. So it's always good to have plans about what you're doing, but they don't, just having a plan doesn't necessarily solve your issues. And so I think that for the aspect of enhancing revenues, the idea of looking for commercial opportunities and implementing those is the best overall strategy.
So the focus on the primary, those parcels that had the greatest revenue potential and development potential, you agree would be the main focus of your strategic planning and your marketing efforts, like Pule Honui and East Kapolei.
For the land division, for things that they're doing that are different, apart from the lands that they're already working on. And of course, some of the lands that we have, there are big issues. But for Banyan Drive, there was a planning effort. There still is a planning effort ongoing, but you have to have the commercial opportunities if your goal is to make more money from the sites that you have. The commercial opportunities have to exist, and we have these issues with these aging buildings that are not easy. And they're being worked on without there being a master plan, so to speak, for them.
Okay, thank you. I have further questions, but let me defer to other members, Chair, so I'll turn it back to you.
Thank you, Chair Tarnas. So up next is Chair Kobayashi. Questions, Mr. Kobayashi? Chair.
Yeah, thank you, Chair. So I just wanted to clarify what you're saying about the lease extensions. We had heard from the land division head that his statement that basically the extensions were based on authorization by the legislature, which we made clear that we authorized, but we did not mandate. And you repeated that as well. And you cited that basically we have a situation where there were tenant-done capital improvements to some of these buildings as some of the reasons. But then your really summary statement really came back to basically you're implementing ledge policy. So is it your understanding that the ledge policy is a mandate or that we allow it?
It's allowed, it is not a mandate, but I really do not think we're implementing the legislative policy if we say that we're not going to renew the leases if we think we would make more money by letting them expire, because then we wouldn't renew any of the leases. And you can see, although most of the extensions were done under the 2011 Act, legislature passed an act, another act in 2018 that applied specifically to Banyan and Kaneohe. And again, if we had the board then took a policy that we weren't going to extend those leases if we could make more money by letting them expire, we would not extend any of them except for the ones where the buildings were so run down that they were more of a hindrance than an asset.
Can I have a follow-up question?
Sure,
so,
go ahead.
One of the initiatives that I think would be helpful is whether a decision made to extend the lease or not, whether it would be a good idea in your mind for it to be, that discussion to be documented for each individual case, and for that document to be something that we can examine and know that the individual reasons for each lease extension were considered and what the mitigating factors were and why that decision was made. To have that be more transparent documentation, I think would be a good idea. Would you agree?
Well, I absolutely agree. And I do think that that's available because every time a lease is extended, there is a staff submittal which discusses what's being requested, the investment being made by the tenant, and other factors. So that's available to the public. The one slight exception would be the first time the Kaneohe came to the board at the end of 2012 for a Kaneohe lease came for a lease extension. The department staff recommendation was to deny the lease extension, and the board, reasons that are discussed in the minutes, decided to extend that lease. Thereafter, all the lease extensions, I believe, were recommended by staff, and so the reasons are presented in the staff submittal.
Sorry, at what point did you start seeing that documentation for 100% of the lease extensions, in timeline-wise?
2013.
2013 on.
Yes.
Okay, thank you.
I can't see if her camera is off, but Representative Okimoto, if you're present. Otherwise, next up would be Representative Perruso, followed by Representative Yamashita. Go ahead, Representative Perruso.
Okay, thank you. And thank you for being here, Mr. Yuan, and for your service. My question has to do, well, I have two quick questions. The first has to do with training for board members, and I've been asking board members for ADC as well. If you have annually received the training offered by Kahuli'au, the Center for Excellence in Native Hawaiian Law.
Well, certainly I personally have received that training, and I know that the board secretary keeps track to see that the other board members do.
Okay, excellent. And then as a follow-up question with respect to that training, because in previous hearings, we've had conversations about ceded land revenue and SLDF. And I'm wondering if the board has conversations about the implications of the fact that so much of the land that you folks are responsible for managing is ceded land.
I believe that the board members are certainly aware of that, and virtually, I would say all the submittals that we have that concern land from the land division identify whether the property is ceded or non-ceded on them, and we're aware of the general responsibilities with respect to ceded.
Okay, perfect. That's interesting because ADC does not have a similar demarcation on their submittals. So thank you for that. And then my second quick question is has to do with you know, there's a lot of conversation around lease extensions and the way in which our current approach to lease extensions might be delimiting the revenue that we could be collecting as a state. And I'm wondering, does the board have any kind of broader analysis of the other implications of not allowing a process for those leases to be extended to other people? And I'm thinking, you know, just about the fact that when you continue to extend to the same parties, then there are folks who may want to participate who are then shut out. Does the board have those conversations, or is that kind of outside the box?
Well, I came back on the board in July 2014, and by that time, there had been quite a few leases extended under the Act 207 of 2011. And so when those came up, I certainly did not raise any special questions about them. It seemed to me that there was a definite pattern and practice that you had to apply consistently from that point forward. Since then, we have both Act 149 in 2018, which applies to Branyan Drive and Kanoe-Lehua, and the House Bill, I forget the act number, but it was House Bill 499 that was quite controversial in this last legislative session, which again authorized lease extensions on somewhat more specific terms than Act 2011 that has this 30% of improvement requirement. My take on that is that the legislature wants you to do that. If you don't want, and you can't, I don't know under what grounds you say to one lessee, you are willing to invest this money and you can get an extension, and another one you don't. If it's general principles like we should let other people have a crack at these leases, why pass this law in the first place? And if it's, well, we would make more money if we let your lease expire and took over your building, why pass this law in the first place? So the board has not, and since on the board level, we have not had a philosophical discussions about whether these things should go out to lease or whether the leases should be extended or whether we should allow it to naturally terminate. That has not; those discussions have not been held. There have been, we've had, I can think of informal discussions on basic policy that I've had myself, I've had with the chair or other people. There is and was a problem with the way state leases worked, with the fixed term and the no possibility for renewal, and then it goes up to public auction because the tenant had no incentive to keep up their building. And in fact, if they did a great job at keeping up their building, it meant that they were likely to have to bid higher against somebody else if they wanted to keep it. That's, because they can rebid, at the end of the term for the building. But that's kind of no, we do, the board has not had these philosophical discussions.
Okay, so so I understand clearly, your analysis of legislative intent as expressed in these multiple measures is that the default, if all the criteria are met, is to extend. Is that correct? I think
that's a good way of putting it, yes. And there are circumstances where you wouldn't. The example might be, for example, Kanoilehua adjoins the community college, and if the community college wanted one of these leases to expand their campus, that would be a good grounds to refuse to extend it, and we could. The law says, you can. There might be a site that's the current type of use is really underutilized. We could not extend it, but I would say rather than I would say that the default would certainly, because we are trying to implement the intent of the legislature, the default is to extend the leases.
Okay, thank you. Thank you, Chair.
Thank you, Representative Perruso. So next we have Representative Yamashita, but I don't see any movement on the Zoom screen. Representative Ichiyama.
Thank you, Chair. Thank you, Mr. Yuen, for being here. One of the points brought up in the audit was this question of the public trust doctrine. And I was wondering if you could tell us as a committee, from your perspective as a board member, what are your obligations under the public trust doctrine when it comes to managing state land? And how do you carry out those obligations as a board member?
Well, the term public trust is used in different senses. And I think that one of the criticisms I'd have about the audit is that they did it in a way that confuses. And they criticized really what amounted to one or two board members' statements of their beliefs as being inconsistent with the administrators, or among the administrators of this public land trust. And as such, we are trustees, and we have a fiduciary duty to the beneficiary of the trust, which is people of the state of Hawaii. And when we have made a decision to allocate lands to commercial uses, we are under a duty to obtain fair market value from those lands consistent with the laws that we operate under. So that's what they were criticizing. The public trust doctrine is something else, which it's a doctrine that says that certain natural resources are inherently public, and the result is that the courts have established a priority of uses and said that they should not be permanently alienated. So this would be submerged lands and water, surface water in Hawaii. And then the third thing is you have the state constitution, which talks about natural resources, public natural resources being held in trust for the public. And again, we have duties as a trustee to guard for the prudent uses of those, but we are not striving to increase revenues necessarily from all of those properties, because there are other public trust kinds of uses for natural resources. So I think if you look at the section in the auditor's report, they do mingle these three different concepts.
And just to follow up on my question, I think, specifically to your role as a board member on fulfilling your obligations as a trustee for lands that are held in trust by the state. How do you see your role in carrying out those obligations?
Well, you try to do your best. And we are guided by, you sit there as a board member and you're always trying to make decisions that are in the public interest. And the guide, and we all have sometimes you may have your personal idea of the public interest, but the state constitution, the federal constitution, and statutes that guide and shape your idea of the public interest. But at the end of the day, that's how you're making your decisions.
And then my final question on this topic is, do you feel like the board members get enough training on these various trust roles and responsibilities to understand the differences that you articulated, or is more training needed, or is there another way to make sure that board members understand their roles and responsibilities?
Well, the auditor criticized training on the role as a trustee and the public lands trust. Also the public trust doctrine. I think that when these come up specifically, we generally have quite a bit of guidance on them, particularly from the Attorney General's office, and they're quite often very thoroughly considered. If both in board submittals, you'll see very extensive discussions of the public trust responsibilities of the board members, and sometimes in executive session. I do feel that the board members, we should have more training, but the specific areas that I would look at are the Sunshine Law and how you act in contested case hearings, because those things are not common sense. And it's easy to make mistakes because you really have to know what those are. And so I wish that the board members had more specifically more training on those areas.
Thank you. Thank you very much, Mr. Yuan, teacher.
Thank you. I want to follow up on this training question, Mr. Yuan. In your experience previously in the 1990s and to the present, is there anything in the training process you think that was done well and has stopped and needs to be brought back?
In the 1990s, when I first came on the board, and I presume that this was done for all the board members, we met individually with each division head. I came over to Oahu and spent an hour or so with, probably not quite that long, but a half an hour to an hour with each of the division heads. And it gave an opportunity to understand where they were going and to establish some kind of relationship outside of the immediate sort of face-to-face across the table formalities of the board meetings, and gave a better idea of what the department was really up to. And so I thought that was good. And I don't know why, but that when I came back in 2014, that was not the practice.
Okay, and then I think one of the big takeaways for me from this audit is that really we were looking and examining a division that is influenced by governors as well as legislators. And so you having worked under or been appointed by 3 different governors, and now we're facing a period of transition, do you have any sense of how the current DLNR is maybe gearing up for potential trainings for new board members as this transition occurs with the next governor coming in?
I don't have any insight on that, no.
Okay, and then could you make any recommendations about how that kind of training should occur, especially when there's a big shift like the training, like a transition with a governor?
Well, just the 2 things that I mentioned is more training on the Sunshine Law and face-to-face meetings with the administrators that actually run a lot of the day-to-day operations. The ethics training is required by law, and that has to go forward, of course, and the Native Hawaiian law training is required by law, and that has to go forward.
Okay, I'm gonna defer now to Chair Tarnas, and we'll go back for another round of questions.
Thank you, Chair. I wanted to follow up on the auditor's criticism that with these lease extensions, we're leaving money on the table. You know, we're not the state is not getting all the money it should be getting. One of the things that I'm trying to get out of this investigative committee process is some recommendations for how we can improve our land use policies and address the deficiencies that the audit has identified. So one of the suggestions that we've been talking about was allowing DLNR to charge rent premiums on extended leases to compensate the state for giving up its reversionary interest. Could you give me an opinion on what you think of that idea?
Well, it's something that would result, the public would get more, a better return. If you look at, the one thing I would suggest, I don't think it's authorized currently, because, and the reason is that the law allows the current lease to be extended, and the current lease rent is a ground rent. It's based on the land value. It does not say anything about the building. I would say that, if there's to be legislation to authorize it, the House Bill 499 was quite generous to the tenants, and that they now have the opportunity to extend their leases for a considerable period of time without the reversion of these buildings. The basis for a premium should be there should be a formula that is clearly stated, rather than well, you may charge a premium for it, because there has to be a fair formula if you're going to do this. And it should be some fraction of the building value, but it also shouldn't penalize the tenant for having taken care of the building, and it shouldn't include the improvements that they're required to make in order to extend the leases. Beyond that, that leaves a lot of leeway, but that's my main comment, is that there needs to be a clear formula that people can feel that they're applying objectively, and not something that does not result in constant haggling.
Thanks, I appreciate that. And I'd be interested to hear suggestions on what that formula might be. You stated it generally, and that makes a lot of sense. So perhaps we can have further discussions with board members and land division on this so that we can try to put together a fair process. Because I definitely heard the criticism, like 499 is generous to the lessees. And so I'm looking to see, well, what can we do to strengthen the state's position so that we get fair market value on our leases? Chair, I'll turn it back to you. I've got more questions, but I want to defer to yield to other members.
Okay, we have Rep. Perruso next.
Thank you. I wanted to circle back and follow up on your discussion, Mr. Ewan, of the guidance that you receive from the AG when you face challenging questions with respect to renewal of leases. And I wanted to confirm that you're relying primarily on the deputy associated or connected to your department. Is that correct?
Yes. Whenever I say the AGs, I mean the deputies that work directly with us.
Okay. And do you ever, reach out to other sources of authority, maybe the Attorney General's office or OHA or other stakeholders?
Well, we almost always have, on major issues, we have lots of input. OHA, I'm not sure how it's transmitted to OHA, but at least they get their agenda and all the submittals and very often provide comments. We would not go, we have a as far as the AGs, Land Transportation Division. Sometimes the board might request an AG opinion, and that's a formal opinion, but it would be signed by the top AG, but it would still be done by the Land Trans Division. Apart from requesting a formal opinion, we wouldn't go ask for a different AG than.
Right. No, I understand that. And I get that. Maintaining harmony. But I wonder, is there a great deal of continuity in terms of the deputy AG? You've served under 3 administrations. And is there a high rate of turnover for the deputy AG for your department, or is that person generally someone who stays in place for a decade or more?
I would say that they're both in the 90s and now, at least in the Land Transportation Division, there has been a very high degree of continuity. Now, Bill Weinhoff was the head when I came back in 2014, and he just retired last year. So Linda Chow took over, but then Linda Chow has been there. I don't know. I think probably in Land Trans, because I see her name in cases, I would say she's been there at least 15 years.
Okay.
And most of the other deputies have been there for quite a while in land transportation. And the 90s was also true that the deputies they stayed with that division. So there was a fair amount of continuity within that group. Yes.
Okay, thank you.
I don't want to miss anyone who might be on Zoom, but might not be on camera. So Representative Okimoto or Representative Yamashita, if you are present, just turn on your camera and then I'll know to call on you. Otherwise, Representative Ichiyama. Chair Tarnas, why don't we stick with a bunch of questions from you?
Thanks. I want to return to the ceded land revenue question. There's been criticism in the audit that revenue from ceded lands, after the funds have been set aside that statutorily required to go to OHA, that the balance of those revenues from ceded lands are deposited into the SLDF, into the Special Land Development Fund. And that was something that was approved, recommended by a staff submittal and approved by the board. Yet the audit criticized that. What's your opinion on that, and how were you guided in making that decision to feel comfortable that those ceded land revenues going into the SLDF do in fact meet the constitutional requirements for spending on the 5 purposes, or one of the 5 purposes?
Well, this is another aspect of the audit that I found quite puzzling. And first, from a legal point of view, I think we talked about this in the informal hearing that the head of Land Trans has written a memo, and I think the memo itself may be confidential, but I think I can say that the general opinion was that there's nothing wrong with this, and that prior to, despite the ceded lands being the subject of innumerable lawsuits over the years, that this comment by the alleged auditor was the first question of that this idea of the deposit of the funds into the SLDF had ever come up. And that, again, from a legal point of view, one of the 5 purposes is the provision of land for public use, and that's basically what DLNR does. 90% of DLNR. And then finally and then it's the statute 171-19, the legislature passed a law that says this is where you put the money. And I'm not sure how the department, what the department is supposed to do when the law says that this is what you do. That's again, this relationship between what the administrative agency does and what the legislature tells it to do. We do what the legislature says. And then the final comment I have is on a practical matter. This is like worrying about whether you keep your wallet in your right pocket or your left pocket. It's all the state's money. And the legislature knows that this money is being kept in the SLDF and accounts for it when they decide on how much general fund money gets put into the DLNR.
Thank you. I appreciate that perspective. Chair, I'll turn it back to you so that other members can ask questions.
Sure. Representative Perruso?
Sure. I'd like to follow up on that question, actually, or really your response to that question, because I wanted to ask then, you developed this analogy about, it's like asking if we want to take the money out of your right, your wallet in your right pocket or your left pocket. And I think that analogy might not work exactly because from my perspective, I sit on finance, and I don't think that we have the kind of control over the monies in SLDF that we do over the general funds. So I wonder if that analogy really works. And I also wonder if the constitutional mandate is being met. So I think it's really hard to answer that question without kind of a thorough understanding of how much money the department is putting back into SLDF from those revenues, and what the other purposes for the use of that revenue are. And I don't think that we are really getting that from the department. So I'm wondering if and I did have a chance to read that Deputy AG's analysis memo. I think kind of justifying current practice, which is, I wonder, like, do you think that because the Deputy AG wrote it, then it's incontrovertible?
Oh, no. However, we are guided by the AGs on legal questions. So it's not that someone could take this to court. I do not think that DLNR, it's not an administrative agency that's going to take it to court. Mm-hmm. The administrative agency has a clear, and this one I will use the word mandate, that this is where you put the money. The legislature passed a law that says this is where you put the money. And if somebody thinks that's violates either I think the technicality would be Section 5F of the Admissions Act rather than the state constitution. Somebody can take that to court. As far as the legislature I do know that the DLNR reports to the legislature how much it generates from leases, licenses, and the like, and how much of that is put into the SLDF.
Right, but it does not distinguish between ceded land revenue and the rest of the lands that I can see, except that it does show how much was paid to OHA and to DHHL from the records that I've seen. So, I mean, yeah, okay, thank you.
Yeah, and about half of the SLDF is from Sand Island, which is non-ceded.
Okay, thank you for your support or your response.
Thank you. Representative Ichiyama. No. I skipped over Representative Yamashita and Okimoto if you're there. Representative Kobayashi, I don't know if you're zooming in now. Okay. I had a question related to the rent increases for revocable permits. And one of the specific recommendations from the auditor's report was that the landlord should reconsider caps on annual rent readjustments. What I found fascinating and, delving into these documents, being a board member is really a second full-time job for many of these board members, because when you look at each of the submittals, the amount of work that goes into it. So I wanted Mr. Yuen, if you could describe the process that was implemented in 2019 regarding the consideration of the revocable permits, because I think actually that was a large sea change in the way that you folks did your process of reviewing the revocable permits beginning in 2019.
I'm not sure the exact year, but what certainly the DLNR started to take a harder look at RPs. And from the board's standpoint, back in the 90s, all the RPs would come to the board for the 4 islands in one meeting. And it was usually the last meeting of the year, which tended to be an extremely busy meeting and very difficult to focus on the RPs at that kind of a meeting. And so what we did, and I can't remember the exact year, but it was break them up so that each island got its own meeting. The second thing was to adopt a format of reporting, which included what were the long-term plans for the property, and how were, if the idea is to get them off of RP status, what was going to happen with them, and to have really instead of just listing the RPs and the amounts, there was a matrix of information about the RPs. So that's quite improved and quite a change. There was also an appraisal done. I hesitate, maybe appraisal is not quite the right word because I don't know. This was done en masse, but it suggested that some of them were undervalued and could be raised. And so for the most of those, staff was concerned that implementing the whole raise at one time would cause some of the RPs to be abandoned, which they didn't want. And so we've been implementing a 10% a year increase on those that are undervalued, except for in the pandemic last year, they were not raised typically. And that's those are the major changes I think that have happened with RP practice. There's also been some effort to move. Some of the RPs are better characterized as easements, and there's been an effort to, make them easements, rather than something that gets renewed by the board every year. It's not the right name for it. It was an easier way to do it originally, and so that's why it happened. So there have been quite a few changes in shared cases administration on handling the RPs.
And is your sense that this is a good process that you're undergoing, and that it is in fact a case-by-case kind of analysis review process that you're undergoing now that you're looking at each of the RPs in the context of island by island and are now able to do a deeper dive into the RPs?
I think it's better, and I think it is improved. The public interest in the RPs, I think, is one, that the state is not getting shortchanged. Two, that people aren't getting favoritism on them, that there are not sweetheart deals being made. I think those are the two major issues. And when I looked, not so much at the other islands this time, but I did look very carefully at the Big Island RPs. And we could go through this sort of almost one by one, but certainly there are a lot that are to public agencies or to nonprofits, and we can put those aside. Those are not in revenue maximizing kinds of opportunities. But if you look at a very large number of them are not of interest to someone or not useful to someone other than the RP holder. They're places, they're properties that don't have good access except unless you own the adjoining property, or pasture lands that are difficult to manage unless you own the adjoining property. There's a big property next to the Kukio Resort, for example. I have no idea what it's very bare land. You can't actually do anything with it, and I'm sure that they have it under RP because they want control. They don't want somebody, they want to be able to, somebody starts camping there, they want to be able to chase them off, for example. But it's not something that if you put it out to public auction, you would find people interested in it. And I think that this is true of the vast majority of the RPs that are out there, that they would not attract public bidding.
Okay, I think that's all my questions on the RPs. I do want to defer Rep. Tarnas. Anyone?
Thanks. I want to follow up on this whole issue of land parcels going out for public auction. And we've heard from the administrator and others that sometimes you just don't get any interest. How would you suggest that we handle this? I know we discussed this in our informal meeting, but I'd be interested in having you articulate what you think might be a good way to approach these parcels if they get no interest in a public auction. What would be the best way to handle this?
Well, staff has always found the public auction process to be extremely difficult. And, just as a matter of background, if you look at the state land laws, the idea is basically that everything goes by public auction. There are a few direct opportunities for direct leases, but they're quite limited. And then you have the RPs. Those are your only categories of dispositions. If you look at what really has happened over the years, many of the existing leases were not public auction. Many of the ones in Hilo were disaster leases. And then in the 1990s, there was legislation that wholesale converted RPs to leases. All Sand Island is like that, for example. So you have a system that really is not working the way the law sounds like it should work. And I think that part of one solution might be to create another category of lease where you could, and I would not say that that you would go to public auction and have the auction fail being the trigger, but you have some transparent, legitimate process where you can determine if there's any interest in the property. And then if there isn't, or if it's limited to one person, then you can have a negotiated lease and not have to go through the auction process. I hope that that's something the public could accept as being reasonable reasonable and transparent, especially if people realize that this whole concept that practically everything is going out through public auction is really not the way it's worked and hasn't worked for probably 30 plus years.
Can you imagine what or any suggestions on how we might ascertain that there's no interest other than the lessee in a parcel without putting it out to public auction? I mean, how could we determine that? Well,
some kind of advertising, because even a public auction, you have a certain amount of advertising, and it could be, for expressions of interest, you advertise for expressions of interest. So it's not that the auction itself creates public knowledge that the property is available. It's the advertising, whatever advertising that goes with the auction lets people know that it's available. And there may be things in marketing that we're missing, particularly for agricultural properties. In that, I don't think that that farmers who are looking for land, that they have the DLNR in mind, for example. I mean, people do come to us from time to time, but I think generally that's because I know, from having the farm out here, that there are people that go and approach private landowners looking for short-term leases. I don't know that they are thinking DLNR when they do that.
Okay, but an RFI or something of that sort might be a tool to use.
Yes.
Okay. Chair, I have another question, but I'm happy to yield to others.
No, why don't you go ahead and ask your question, Chair Tarnas?
Okay. One of the suggestions that we've heard is that specify that the lessee, that the legislature might consider legislation to specify that the lessee pays for the appraisal required for reopening the rent in an extended lease term, and that the lessee is precluded from protesting the rent so determined. What would you think of that proposal?
Yeah, I'd have to think about that. I don't have a reaction right off the bat. Yeah, I don't have a reaction right off the bat for it.
Okay, that's fine. I'm just, if you have thoughts later on, I'm welcome to hear them. That's certainly something we're considering.
Though that the lessee, if they are getting a lease extension, maybe they should pay for the appraisal.
Okay, just a thought. Thank you. Let me turn it back to you, Chair.
Thank you. Representative Kobayashi.
Thank you, Representative. So I just want to go back to the public trust doctrine discussion that we had. One of your comments regarding the public trust doctrine audit finding that they elaborated on an audit report that you characterized as a criticism was that you found it very confusing as to whether they're talking about your public land trust fiduciary duty or the public trust doctrine. They elaborate with the public trust document as defined by the Attorney General, the three specific trustee obligations to the state. So I think that's fairly clear. But really the gist of what they're talking about was some apparent misunderstanding among land board members relating to public trust doctrine versus what they consider a good tenant doctrine. So according to one land board member, if you have a good tenant, you should do what you can to keep the tenant. Also that there's public interest in extending, in this case, they're discussing KIA leases because it would maintain economic stability in East Hawaii. And also made the point that the state's lessees are members of the public, meaning that they should be taken care of also. A lot of these comments point to situations where you would be putting the interests of individual lessees above those of the rest of the public. So is that your understanding? Is it consistent with the comments that I'm seeing in the audit report about different views on what constitutes a public interest?
Let me just say from the public trust doctrine, as I understand it, the phrase came in an article by a law professor named Joseph Sachs in the early 1970s. And I wish that the legislative auditor had not used that phrase in this discussion because I think it muddles it. When he starts to talk about the Roman roots of the public trust doctrine, that's a doctrine that some natural resources are inherently public. Then it talks about something that is different, which is our duties as board members, as a duties of administering the public land trust, in which we have a fiduciary duty as trustees. There is a quote by a member of a past member of the board that I personally disagree with. And you certainly can interpret that quote as putting the interests of the lessees above that of the state as a whole. I disagree with that, the sentiments that seem to be expressed in that quote. I'm going to assume that the auditor has correctly quoted the person in question. The other quotes, it really is a matter of interpretation because I'm a private landlord, and as a private landlord, if I have a tenant that is paying the rent and not causing me any problems and maintaining the property, I want to keep that tenant. I do not want to substitute with a tenant that might pay me a little bit more. I'm not going to make a drastic adjustment in rent, but there is an interest in you as a landlord in maximizing your revenue, in having a consistent revenue stream, and not soliciting tenants all the time. So yes, if you're saying, if you're saying, well, I like, I get my car repaired at Joe's Motors and he's a good guy, and so I want to keep Joe's Motors in business, and as a land board member, that's not right. But if you're saying Joe's Motors has been there for 50 years and paid their rent and kept up their premises, and we would, and if we can get fair market rent from Joe Motors, let's do it. That's, I think, what a private landlord would do in the interests of their own self-interest, and I think that's what we should do as land board members in our interests of the public. I think you do, even if you theoretically can get more money leasing it out, there's no guarantee to somebody else. As long as, if you're talking about a small amount of money, relatively small amount of money, you have problems with vacancies, you have problems with tenants who turn out to be unreliable and don't pay you. So that concept, the concept of keeping a good tenant is something that can be in the public interest. As I said, to start off with, the way that one of the board members was quoted, I would not try to defend.
Thanks. So I think that's really the missing piece when we're talking about the documentation on really coming up with justification for why or why not we would be doing lease extensions. And when you look at the documentation, a lot of it makes certain assumptions as to what the responsibilities are under different fiduciary responsibilities, both in the public land trust and the public trust doctrine, and other mitigating issues related to good tenants, relating to community good, and other non-revenue generating objectives that we may hold. So to have those what the objectives are under the various doctrines that you have to operate under, clearly defined, then we can point to them in the justification and say, okay, as we defined, these are our goals. This is what guides us on it. And then I think it becomes less open to question as to why these things were done. Because like you say, things were, for the most part, documented in recent years, but there's just kind of a leap as to what are legitimate reasons and what are not, because they have not really been clearly defined, which speaks to going to our strategic plan and issues related to that. Thank you.
Representative Perruso.
Thank you. I'd like to circle back to the relationship between a possible strategic plan and kind of addressing these larger, what you call philosophical conversations or concerns. I see them as concerns of the common good. And I think that I heard you saying, and maybe I misheard, but what I heard you saying was that there may be planning around specific lands or specific projects, but there currently, and this is also in the audit, there currently is no broad strategic plan to address a long-term vision and for these lands. And I'm wondering, because you seem to keep coming back to your reliance on the expression of legislative intent. And I'm wondering if you are waiting for us to express that vision, or if that's something that you folks, your board, feels empowered to articulate.
Well, we all have long-term visions. And so when deciding what to do with particular areas of land, very often this is in service of a long-term vision. So this department moved many thousands of acres into the natural area reserves in the last, from roughly, I'm talking 2012 to 2016 or so. And that was in service of a long-term vision of establishing a higher protected level for these lands. We acquire land for conservation purposes and public benefit. There's a long-term vision involved in that. The board authorizes these acquisitions. And so there are many things that are done that involve a long-term vision. It is hard, though, to state this in terms other than generalities that people can, people agree on these generalities, but I don't know how useful it is sometimes to just lay out them out. You have multiple ideas about the proper uses of land. I think that the audit is focused mostly on land that is with the land division. And for the most part, those are lands that we have decided revenue generation is a big part of the picture. There are also, some of them are, to nonprofits and the like, but it's different than state parks, for example, or the forest reserve, where revenue generation is not a big part of the picture. It may be part of what we're doing, but it's not why we have a state park or why we have a forest reserve. On the other hand, well, we do, I somewhat hesitate to establish, let me try to explain this. When you have your revenue generating lands, I hesitate, there are other public policy implications. And as a board member, I hesitate to push those absent some clear legislative intent. And let me give you an example of Kanoilehua and Banyan Drive. They're both crucial for the economic vitality of the Hilo area. How much, and I think that now with the legislation that's been passed, it's clear that apart from just making the most money you can from them, that there is a strong legislative intent that Banyan Drive be a center where you can have visitors and it's attractive to visitors. And Kanoilehua is an area where you have small businesses. And this could be a conflict, really, you know, because you could have lease sizes that are amenable to smaller businesses and may make you less money. And you could have a lease size that's amenable to a Home Depot coming in and make you more money. I think now we have legislative intent for that. But absent that, I don't know how much a board member can say, well, I am going to push for something that is good for small businesses and may make us less money than something that is, you know, attracts a big business.
I was actually thinking of an approach towards strategic planning that is grounded in community. So I was thinking that it would be precisely that space, that process within which you can have these very important conversations rather than relying on folks who hold particular positions on the board, because I think it has broad social implications. How we use our land is, I think, the most important question. So that's kind of what I was getting at with the strategic plan approach. But what I hear you saying is that you don't really see the board as kind of as a social organizer. You see them as making like discrete decisions about you know, submittals that come to the board, but not really reaching out or doing strategic planning or anything like that. Is that accurate?
Well, I agree with you that the decisions about how you use land are the most important. That's why I wanted to be on, you know, you volunteered to be on the state land board, and that's why I did. And that's why I took a job as Hawaii County Planning Director. I do think that it's important to make the individual decisions, you know, and that it's difficult to, if you're thinking about making a new revenue producing area, a new industrial or commercial area, there is quite a process that you wind up going through. And you're going to get the public input you know, the whole time along the way. So if you do this if you try to master plan out the island, for example, or the state of Hawaii, and you're going to wind up possibly getting into a lot of fights over things that you are never going to be able to implement anyway. You know, if you actually sit down and you did a master plan that's a map, you're likely to have a lot of conflict over, you're saying, well, this area becomes conservation and somebody has a different idea. Oh no, we should put housing there. And maybe you're not really going to be able to implement either idea. So then then you may end up having a strategic plan that consists of a lot of very general statements that everybody would agree with, but they don't do you that much good. That's
so you think under these conditions or in this kind of context, strategic planning is of little value with respect to these lands?
I'm saying that you just have to be careful about what your expectations are.
Okay, thank you, Chair. Thank you.
Okay, next up is Representative Ichiyama, I think. I don't have any questions at this point. Rep. Tarnas.
I don't have any further questions. I just want to acknowledge I just want to say thank you to Mr. Yuen. But I have no more questions, Chair.
Okay, Rep. Kobayashi or Rep. Perruso or anyone else who may be on Zoom but off camera? No. Why don't we are a little bit ahead of schedule. We'll take a 2-minute break so that we can get Mr. Tar situated. And Mr. Yuen, you can go off camera if you want, but if you would stay on, because I think we'll wrap this up and questions may come back to you at some point. And
Okay.
again, we're aiming for 4 o'clock, 4:30.
Okay, thank you very much for these questions. And I, just in response to the last question, I think that strategic planning can be useful. I just really think that it cannot be seen as a panacea for a lot of the problems that the department has to face with. And that are a lot of these things, there's a lot of conflicts that are inherent in what the DLNR does. We try to navigate through them, and sometimes you make one side happy and not the other. And that's kind of what the way these things go. But Chair, I'll be happy to be available. I'll take myself off camera, and I'm happy to answer any more questions the committee may have later. Thanks for these very probing and thoughtful questions.
Thank you, Mr. Yuen. And so members, we'll take a 2-minute recess. 2 minutes.
Thank you, Mr. Yuen.
321. Reconvening our House Investigative Committee. Today is Monday, November 29th, 2021. It is now 2:35 and we're continuing our 1 p.m. hearing. Members, we have with us Board Member Vernon Char here in Conference Room 325. And present members is myself, Vice Chair Ichiyama, Chair Mark Hashem, Chair David Tarnas, and Representative Amy Perruso. We may have others joining us via Zoom and in person, so we will tag those people for questions as we come up, but let's get started first with Mr. Char being sworn in. Mr. Char, you heard my instructions and questions to Mr. Yuen, so we have to start first with swearing you in, so if you could please stand. Swear you in. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And let the record show that Mr. Char answered that in the affirmative. Mr. Char, thank you. So just like with Mr. Yuen, if you could provide some of your background as related and relevant to your position as a board member, just to provide some information to the committee about your position on the board.
Thank you very much. Appreciate the opportunity to be here. My name is Vernon Char. I've been a practicing attorney for many years and have served with the state in various capacities, initially starting with the Attorney General's office when I first came on board. I then was also on the State Ethics Commission, being on the initiation of the Ethics Commission when that law was passed. I've served on the Hawaii Tourism Authority for 8 years as well. And now with the Land Board, I had a brief appointment, I believe in 2014, and then came back on board in October of 2019. So insofar as the Land Board is concerned, I'm still a relative new member and still in the learning process. I've otherwise done activities besides my practice of law, activities at the university and in the community as well. So I'm here to respond to any questions that might be asked. At the outset, let me also clarify, I was not on the board at the time that the audit was conducted, but I have had the opportunity to review the audit report. And by like token, the responses from the department by Chair Case, I was not there for the initial response. And unfortunately for me, when she did the second response in June of this year, for that particular meeting, I was in the hospital. And so I was not privy at that meeting where the June 25th meeting, or when that letter was written. But I have familiarized myself with all of the correspondence and the audit report itself. So I'm open for any questions.
Why don't I start? And it's a general question like I asked Mr. Yuen, but were there any big takeaways or impressions that you had about the audit as a board member, and understanding, of course, that you weren't present during the time the audit was being conducted? Was there anything big takeaways for you or impressions that you had of the audit report?
Yeah, I think one thing for me as I look at it, being a new board member, is the context for the Land Board and myself, if I could dwell on that for a second, because I think it will reflect on some of the answers that I will be giving. We're 6 lay board members, and then the chairman is full-time. We meet every other week, and our meetings last at 9 o'clock, 2 o'clock, and sometimes go on to 10 to 7. We've had several meetings this year where it goes from 9 to 10 to 7. on Zoom with the COVID situation, but a fairly lengthy day. The board book are about, you as legislators know a lot about reports, but it takes me at least a full day to go through all of the agenda items in the board book in preparation for the meeting. And in that regard, many of the times when I look at the board book, I will contact the staff or Chair Case to get further background. So we do quite a bit of homework. One other general context, because when I looked at the audit report, I thought it was important to get a review of the land division. The land division, under the ceded land and the subsequent public land, the audit report talks about 1,300,000 acres of land that's under our purview. That is correct. However, almost 1 million acres is in forest preserves and conservation area. They're generally not commercially viable for retail or commercial. So when I looked at this report, it was important for me to look at the land division only, which I think has maybe 40 out of 1,000 members that's on the land board staff, so that I could place in context this audit and my preparation for today. So coming back in summary, the land division is very important, but in the overall framework, it is just 25%, maybe even less of our time issue on what we do at the land board, dealing on land division matters. So
I think that's a very important context. So thank you, Mr. Char. And we'll probably be getting into more specific reactions as we ask the questions.
okay, thank you.
But I think, again, that's very important context. So we'll start off with Chair Tarnas. Chair Tarnas.
Thank you, Mr. Chair, for being here, and thanks for your service. I wanted to get your general impression because of your, strong legal background and service in the state and outside the state. When we look at establishing lease terms and the actual amount of money that would be paid to the state and evaluating lease extensions, you're trying to balance what is fair market value to the state, but also other non-monetary benefits and public purposes that are part of the calculation. Could you give me some sense as to what is your personal calculus, your personal process that you use to determine what is fair market rent that also includes these other non-monetary public purposes that you have to balance? Could you just describe that for me? That'd be helpful.
So when I look at our function on the board, if I am thinking commercial property as distinguished from conservation or ocean properties or so forth, if I'm only concentrating on commercial, I'm governed by my experience, having been an attorney for many years, dealing with both representing landlord and tenants and commercial development. And then I switch over to the state, my board hat, and I'm saying, on top of that background that I have, I also have to look at public interest, public trust, and the statutes and the various litigation that we've been through and so forth. And certainly one of the major items on commercial property would be to maximize the economic benefit for the state on public lands. But I'm also governed by looking at, say, land use commission or city issues on zoning and so forth to see what is the best value we can get with those circumstances for a particular property if it's developed or if it hasn't been developed yet. So there's a matrix that I kind of go through when I think about my role sitting at the land board for commercial property as to trying to evaluate what is in the best interest with my fiduciary hat.
Is the staff submittals that you receive, do they cover all of the various factors in your matrix? Do you find that the staff submittals are comprehensive that way?
Yes, I think I do. And then the reports, for instance, that come in and all of the action items has a wealth of background and information that we take into consideration, that I take into consideration as well. I have to rely to some extent on the staff's recommendation and their background on if it's an existing tenant or existing property in a developed area, as distinguished from, like the Kapolei, where they're looking at some new development there. So I do rely on the staff, but I also, I think, rely on my own common sense, so to speak, of the experiences that I've had in dealing in these same matters and making the comparisons.
I'll yield to other members and my turn once you go around again.
Okay, I think Rep. Tarnas, you're a little bit fading, so I don't know if you can adjust your microphone, but I'll move on to the next questioner. So Representative Kobayashi.
Thank you, Representative. So I'm really glad you're here. Thanks for coming, Mr. Char. I think you bring a different perspective from others we've talked to, given you are taking a relatively fresh look at it, being somebody who's come in kind of after a lot of the issues that we're addressing took place. And also given your significant legal background to be able to look at this with an eye towards what's legally right and what is right compared to what is wrong. We asked general questions to start off with of other the other board member as to just your general thoughts about the issues brought up related to the RPs in the audit report. Do you find those to be of substance, or do you have issues with them as to being overreaching or incorrect, or is it kind of mixed? I just in general.
Yeah, I think in general, just the limited time that I've been on the board, there has been an improvement in looking at the RPs. Because we have so many items on the agenda that we have to accomplish in a meeting, we do look at those items that are flagged. I think Board Member Yun, having the experience that he has had on the board, I rely on his statements a lot, but I also rely on the staff. Now, looking at the RPs, for instance, I think there's been a conscious effort, and I know there was an accusation that we rubber stamp or we just have a 3% cap and things of that nature. I don't find that to be the case. I think we look at each of these leases. The RPs are taken county by county, and I look at all of the RPs coming through, and there's a certain amount of categorization in my own mind, and I do ask questions. There are certain of the RPs that are not susceptible to real commercial economics solely. I mean, it could be piece of property that's a kuleana that has no ingress egress. And the only practical person to use it would be the adjacent landowners. I look at some of the property that are pastured. I notice a lot to Gain Robinson and Parker Ranch. And I've asked questions as to whether at some point we shouldn't think in terms of maybe even doing a land swap to get property that may be more productive. But I'm also guided by a lot of these pasture lands that are also important for wildlife, and the forestry people have their views on it, or may have Hawaiian significance. So take a look at that. And we do look at each of the items. In fact, one of the more valuable things is they give us the prior year's report with a strikeout as what changes have been made. And so we're able to go through it fairly quickly, but there is, at least for me, I do look at, the number of RPs that come through and the ones that are commercial, more so than some of the others that might be, cocaine cabin rental, things like that.
Great, thanks so much.
Representative Perruso.
Sure, and thank you, Mr. Chair, for being here. So my question is really, I think that you've heard the previous conversation, and I was wondering if you had any comments you wanted to add with respect to either the board's consideration of the uses of ceded land revenue or of this criticism in the audit about the lack of strategic planning in either of those two areas. Did you want to, did you have additional comments?
Yeah, I guess I do. I think strategic planning, master planning is a good thing, asset management. The one thing though that I hark back on is there's such a diversity of properties. And so to master plan and speak to all of the lands is very difficult. There's been talk about 1.3 million acres, but if you take 1 million acres and put it into forest reserve and conservation, then I think when you talk about land, it becomes more useful to say not 1.3 million acres, but the commercial property. And if you're going to master plan, maybe take a look at what's in developed areas versus to be developed areas, new areas like maybe Kapolei. I think another thought when you talk about master planning is to see overall other agendas such as agriculture and the need for agriculture. And so when you say master plan, one plan doesn't fit everything. I think they're all land, but to be meaningful, you've got to look at the specific category. And if you're talking about commercial developed property or potential new property, I think we ought to have plans, but broken down to a point where it's meaningful, and not just talk about all land or ceded land, or to me, when you talk about that, it gets into the generalities, and then that would not be helpful either to the board or to the public in trying to understand it. So part of it, I think, is trying to talk about the complexities in the background and context, and then set up these specific plans.
Thank you. That was very helpful. And did you have any additional thoughts about the board's kind of conversation around ceded land revenues or maybe lack thereof?
Well, the one other thing, I think there was a question asked earlier, and I'm not sure whether it's responsive to you, but I did want to comment on the education. Because I'm going through the education now as, you know, for this last 2 years, and I'm learning a lot by attending the meetings and listening to, you know, people like Chris Yun, who's been on the board now coming up almost 16 years with his 2 terms. I've done the Hawaiian study program, and I found that very useful. But I've also done the Sunshine Law. I very interestingly attended the ethics section. Unfortunately, with COVID now, we're not able to. I would love to actually go and have meetings with these. A lot of this has been online. I've also discussed with Chair Case and also people in the land division that I'd like to go out and do more tours when things free up, because I think I can learn more, for instance, in the water issue on Maui, if I could understand the history and where the maps lay out and how the rivers flow and where the dams are and the need for the farmers and so forth. That would be very good. To the extent that we have COVID, though, I have taken classes with the land division. We've got one set up with OCC, the coastal land, coming up next month. And I'm hoping to learn more and get more training, but I'm very open to it, and you know, I welcome that.
Thank you. I think that your commitment is commendable. So thank you.
It's been wonderful for me. It's been a learning experience, and I really appreciate that.
Chair Hashem. Representative Ichiyama.
Thank you, Board Member Char, for being here today. I'd like to just follow up on some of the remarks.
I'm sorry, I can't.
Oh,
My hearing isn't very good.
can you hear me better?
Yes.
Could you elaborate more on your thoughts on the audit after your review? Are there statements that you would agree or disagree with in the audit?
You know, when I looked at the audit report, there's several things struck me. One, that it needs to be looked at and contain what it stands for, which is really the commercial property for the land division only, and not the full plate that we have. Insofar as the public trust issues, being an attorney, serving on the Ethics Commission, I'm very much familiar with fiduciary relationships and the need for that. And, you know, I think I look at that and I think we do a pretty good job, what I've witnessed with my other board members currently on a fiduciary relationship, both in what is in the best interest of the state, what's in the best interest of the land division, economic production, and then also use of the property. So that land trust issue, I think, makes sense. Where I was confused with the auditor's report was the setup of, excuse me. You know, the five elements of the trust, and that, you know, aside from putting monies into the public, I mean, to OHA, we did not, well, let me take it back. There's reference, I think, that on the public funding that there are 5 different segments. Hawaiian was one, education was another, public land approval, use, and I forget what else there was. And with the exception of segueing into the monies for OHA, I think the balance of the funds are used as required by statute for the various other functions that the land board has. And so I was confused when I read the auditor's report. I didn't think he meant that we should take 1/5 and give it to the education department, or 1/5 for, you know, some of the other segments that are noted. So I was a little confused on that. I think all that we do is in the public land interest. So I think we satisfy the Constitution and the statutes.
Thank you. Let's see. We'll circle back to Chair Tarnas.
Mr. Chair, one of the things that I'm trying to get out of this investigative committee process is what kind of policy changes we should make at the legislature to improve the performance and improve the capacity of the land division and DLNR. So one of the criticisms that we had received is that, you know, these lease extension bills like last year's HB 499 were very favorable to the lessees. So one of the things that we were, the criticism was that the state in the audit, criticism was that the state is leaving value on the table by just extending the leases. And so one of the suggestions that we're considering is, should we pass a law that would allow DLNR to charge a rent premium on extended leases to compensate the state for giving up its reversionary interest in those improvements? Do you have any opinions about such a proposal?
Yes, I guess, you know, this is an area that I think I've had discussion with the Attorney General's office, and I think one has to take a look at what the existing leases state. I had an idea myself as to whether there might not be a possibility of having, if we extend the lease, to provide a rent reopening at the time that the original term was up and into the extended term, to then include a factor of the improvements on the property. Because at that point, whether technically the improvements now belong to the state and should be a component and shouldn't be only a land only, but the improvements that are on the land. That's done, you know, outside of the land board issue. That's done, you know, downtown with the other real estate leases that I'm familiar with, very much taking into consideration the remainder interest values, both in appraisals and in dealing. I'm not sure how that would be, how that can be done with the legislature amending it, because there are existing contracts. But anyhow, one idea I came up with, but I've got to run it up with the AG, is whether there's a possibility of saying on rent extensions, without legislation now, on rent extensions, whether the extended period would have rent reopenings, which would then be able to contain the improvement value. You know, I don't know.
In the same light, if we were to have a rent reopening in an extended lease, one of the other suggestions was that the lessee would pay for the appraisal and that they would not be able to contest whatever the appraised value would be for that newly set lease rate.
Yeah.
Well, do you have any comments about that? Any opinions about that?
Yeah, I guess I'm Honolulu on that myself personally. I've seen too many appraisal reports. I don't think there should be some flexibility. And if we tied it with that specific provision, I don't know whether, I'm not wise enough to say that it wouldn't be counterproductive at some point in the future. I don't know. But the one thing that in my experience, have experienced is that sometimes too much law is not a good thing, in that we get into a bureaucratic gridlock, and then we cannot move. I think one of the things I'm very much concerned about is what the system can move without new laws and new restrictions and new vantage points. I mean, already, for instance, on water rights, we're stuck in the court and environmental impact statement and appraisal valuation techniques and rules and contested cases and court hearings, that we've not been able to move some of these real important areas for the community. And the other thing that I look at in the same way, maybe philosophically, is that we're in some real transition periods and some real opportunities now where the Big Five and the sugarcane and the pineapple era is over. The kingdom period part of that is over. And we now have to look at what can we do to develop the properties with new visions on environment, on promoting agriculture, on building the economy. And I think we could be at a real transitional area, and then I get stuck with legislation and contested hearings and things that take 3 years and we still hasn't come back to the board. I don't know what the solution is, but I certainly am for moving things forward.
I appreciate your
I
admonition.
haven't answered your question, but anyhow, it's just my safe frame of mind.
I appreciate your admonition that more legislation is not always the best solution. So,
It can be very helpful, but it can be, yeah.
yeah, we have to be discerning. I appreciate that.
Yeah, and I think you have been.
Thank you, Mr. Chair. Back to you, Chair.
Thank you. Representative Kobayashi.
Thank you, Representative. So really, when you cut through a lot of what we're talking about relative to the audit findings that we have here and some of the responses to that, really at issue at a basic level is this. When you look at the audit findings, they touch on a number of different areas that have benefited lessees in their mind and based on the audit procedures performed. But the overall picture when you look at this is that really the implication that a lot of this has been done not as a matter of bureaucracy or procedure, but with an intent to benefit lessees, where they're, because of personal relationships or whatever reason there may be, to really transfer public resources to the lessees via below market rents or other favorable extensions. So, and on the other side, what we've heard from both land division staff as well as board members on the land board, most recently Board Member Ewan, was that absolutely not. There's none of that occurs, and it was acknowledged that I think the way it was put was that the public is concerned about sweetheart deals, meaning I don't think you missed the implication of that the lessees are getting benefit of public assets at below market rents because it's a sweetheart deal, not because of any other reason. And that is denied emphatically every place. You've been around a long time, and to have a situation where you have public resources at play and significant moneyed interests in Hawaii do not insert themselves in that allocation process would be surprising to me. But in this world of how we're going back and forth on this, on one side, the implication is that, of course not, moneyed interests would never, ever insert themselves in the process and get any undue benefit. As a relatively new board member that's seen how things work here in the state of Hawaii for a long time, would you support that this process is absolutely absent any outside influence by the influence of the lessees?
I have not experienced any sweetheart deals. There are instances even that I'm careful about to recuse myself if there's a client or a former client relationship, and on several cases, so I've recused myself. So I've not, I can honestly say I don't believe I've ever been involved in a so-called sweetheart deal, which would, in my view, be a breach of fiduciary relationship, nor have I witnessed it in my several years on the board. The one instance that was spoken of by the auditor, I would take exception to. I think if that was a finding, that was wrong. But I also wonder whether it was taken out of context in the sense that there may be other practical reasons, like a good landlord wanting a good tenant, someone that's reliable, that's an anchor tenant, and giving a reason to extend the lease or continue the lease or continue the relationship, like an Alamo and a shopping center wanting to, continuing a Macy's there. But insofar as the auditor's report specifically, if that one statement attributed to, I think, a Hilo property, I would, if I were on the board, I would have taken great umbrage at that. And as I said, I've not witnessed anything of that nature in the 2 years I've sat on the board now.
So since you've been on the board, have you been ever been contacted by lessees to try to influence decisions?
I was called by one person and I said I would not have any conversation with that person. And in fact, if it got beyond that, I would recuse myself and not take part in the proceeding. But I have not experienced any effort to influence me for, quote, friendship and not fiduciary relationship to the state.
Great, thank you.
Thank you. Representative Hashem. Representative Perruso.
Thank you. I do have an additional question for Mr. Char and also for Mr. Ewan, if you want to jump in. So we are looking, as you know, at 2 different audits, one for SLDF and one for ADC. And you may or may not know that ADC has, as part of its portfolio, multiple commercial properties and industrial properties. And as we kind of look at how to improve and narrow and streamline the mission of ADC, and as we also work to perfect the work that you folks are doing around commercial land, do you think that there's that it would be wise for us to consider the possibility of transferring those commercial or industrial properties to the portfolio of SLDF? Or do you have any thoughts around that?
Chris, I'll defer to you.
No, I don't know anything about commercial and industrial properties that ADC has, so I don't want to say anything.
Okay.
We don't have any opinion on the
Nice.
ADC situation. I've not reviewed the reports. I'm not fully aware of what that is, so I couldn't recommend anything. I mean, I would for the public lands that we have, I do know that there is from time to time consideration on transferring properties to the Department of Agriculture, and if we did so, I would take a look at that and see. I would want to know from the Department of Ag what their intentions were and what their potentials were. And then I think in some instances, there are even reversionary clauses that property could come back to the land board so that if it was not utilized for an appropriate assignment purpose, that it would revert back to our purview under the public trusts.
That's true. I've seen that, and thank you. That's I am interested in that possibility, but I hear both of you expressing great hesitation and some reluctance, and maybe it's just because you're not familiar with the properties in their portfolio, but I think it's, you know, when I think about ADC. And the diversity of their responsibilities and the difficulties they're facing, I do think that it is something of a practical problem-solving approach to think about who else could be managing those commercial lands and industrial properties. So maybe just put that in the back of your brain.
You're asking specifically about the ADC and not the Department of Ag as a whole.
Correct, but the ADC is attached to the Department of Ag, so the Board of Agriculture would also be involved in the process. And I'm just, this is a speculative question, so it just occurred to me. So I was wondering if you had thoughts on it. Thank you. Thank you, Chair.
Thank you, Rep. Perruso. Rep. Ichiyama. Rep. Tarnas, back to you.
Thank you. Mr. Chair, did you have any perspective you want to share with us about the practice of capping the annual increase in rent for RPs? Or any comment about how you review the RPs? Because that was quite a discussion in the audit. Do you have any perspective on that?
I think we're doing an adequate job. I think since the audit, we have been looking at the properties a little bit more critically. At least the last 2 years, there seems to be a lot more review on the individual RPs. I don't see the need for any legislation or specific changes at this point that would be across the board. A lot of the RPs are really individual as well that we need to look at. I mean, it may be not really commercial property. And then there's also properties that I think are turned over to the various counties. I know we've endeavored to do that with Kauai for affordable housing. So that's been another area of look-see as we look at these lands, some of which is in RPs.
Thank you. Chair, may I ask another question?
Sure, go ahead, Chair Tarnas.
Thank you. One of the suggestions in the audit was that the DLNR should be looking at space leases, not just land leases. So we should, take the improved land, improved property back with the buildings, and then rent it out, manage the properties, and get a higher lease rent. Do you have any opinions about that recommendation, whether it would work or not?
Yeah, I do in this sense. It sounds good, but I think the land division, which generates this revenue, are 40 members, just 40 employees out of 1,000 employees. And I guess a good portion of the revenues come from SIBA, which is they're managing their own property. I'm not sure whether we have the staffing to go out and begin creating another Ala Moana shopping center. I think we're looking at that, but then to run and operate it, that's a possibility. But again, whether you want a state employee to manage a development, I don't know. I'd have to look at the specifics of it. I wouldn't say 100% yes, but I'd be somewhat skeptical of uniformly saying that the land board should get into the land development business. Again, if it all devolves back on the 7 board members, maybe in one, I wouldn't have the time or the background to know enough to pass on those things. So I think, one thing that's worked out very well with the land board that I see also is we've partnered with a lot of institutions, with nonprofits and so forth. And that's been a way of taking the responsibility, but having other operating partners undertake the task as well. And that may be a possibility. I don't know.
Chair Tarnas, you're muted.
That's all. I don't have any further questions right now. Back to you, Chair.
Okay, thank you. Chair Kobayashi.
Thank you, Chair. So I just want to touch on some of the issues raised in the audit report, findings related to Sand Island Business Association. That they raised a number of issues there. I think the overriding big picture issue was that basically the rent from Sand Island is close to, at the time of the audit, was close to 50% of SLDR's revenue. Yet they operate, SIBA operates the industrial park without any regard to the master lease. And they have a number of examples there regarding that they have long-term lease rates locked into place for far into the future, really 25 years, that they had a public road that was constructed, should have been dedicated to the city and county of Honolulu. They still have not done it. This was back in 1999, that they have free parking, which is estimated, that's on the commercial center space there, estimated to have value up to $500,000 a year by the year 2047. what is your read? I'd ask the general question about, obviously SIBA, a very influential organization politically. What is your read on this situation, that this is done out of a sense of them being a good tenant that just needs to be extremely accommodated, or that there is any other reason for the public benefit that they would be doing this with Sand Island in particular?
Well, this is one of the areas in which I would recuse myself. I do have a client that has several lots there. And so I think if it came back to the board, I would recuse myself on the Sand Island leases.
Okay, I respect that. Thank you.
And
I
so
realized there was a
I
conflict.
would defer in answering your response because I think it would be irrelevant. Whatever opinion I have would have some bias.
Okay, thank you.
Can we direct that question to Mr. Ewan, if possible? Because I don't want us to lose that question. And Chair Kobayashi put so much effort into it. Chair Ewan, or Representative, excuse me, Mr. Ewan, are you still there?
Yes, I am. Just a second and let me start my video here. Yes, there were two specific criticisms, I believe, in the Sand Island portion of the audit. One was that the department should not have basically pre-negotiated the rent reopenings, and which is a major issue. I can understand the criticism. All I can say is I believe that went to the board before I was there, and I don't spend a lot of time mulling over decisions that have been made before my time. And the second was on this 1 acre parking area, and I believe that was fixed. I can't give you the details on it, but we fixed that in 2-3 months ago when some issues came to the board concerning Sand Island.
Maybe another way to rephrase this question, and I don't want to lose this because this was a big part in the audit. Mr. Ewan, do you think that the board is in a good place now where it can better manage the SIBA leases, knowing that it's locked in, right, for the term that they've already agreed to? Is the board taking the appropriate steps? And even though it may be a while into the future, that for the next go around, a process will be in place to fairly negotiate and renegotiate this lease? Is there a sense that there will be a better process in place, perhaps?
Well, the rents are set. The rents are set for quite a time in the future, and there's really not that much between, a lessee in that situation and the landlord, other than the rents, and they do a good job of maintaining the property. We did have an issue that the primary reason it came to the board about 3 months ago was the question of the dedication of the improvements. And I had a lot of questions about that. The lease calls for the improvements to be dedicated to the city and county, and they have not dedicated, the way I remember it, they had not dedicated the roads, drainage, and sewer. They had, I have to say that I think they have a good reason for not wanting to dedicate the roads. There's major security issues. If you dedicate the road to the city, the public has access 24/7. And they don't like that, and I can understand that. And partly I feel sympathetic because I think that in many respects the government has failed the citizens in being able, for the citizens to be able to feel that they can just entrust their property without having security guards and the like in a situation like Sand Island. The difficulty, they were still going to explore this further, whether they could dedicate the sewer and the road and the drainage to the city and county without dedicating the roads. The indication had been that they could not. I am concerned about them not dedicating the sewer because someday, you know, whether the leases are extended or not, if it's not extended again, it's, you know, it's going to come back to the state. And if the sewer line is bad at that time and it's dedicated, it's up to the city and county to fix it. Otherwise, if it's not, it's going to be up to the state. So those are my concerns at the board meeting. But other than that, you know, I think that SEBA was the basic solution. I don't want to criticize, I'm not going to criticize the legislature for converting it into a lease. It was a bad situation. And we have a much better situation with SEBA, the long-term lease, and the people having secure tenancy on the property than was the case in the before the legislation was passed around 1990. And they do a good job of certainly maintaining the property and turning over $11 million a year to the state without an enormous amount of oversight being necessary from the government. So those things I think are very much positives. I do look at the circling back to this premium notion though, you know, the fact remains that at the end of the lease, before the House Bill 499 was passed, at the end of those leases, those buildings would have belonged to the state and the state would have stood to gain considerably greater revenue. And if they are extended under Act 499, that time is delayed, you know, for a number of years.
Okay. Thank you. Thank you for letting us interrupt, Mr. Char. Going back to our lineup, Rep. Hashem, anything? No. Rep. Perruso?
No more questions.
And no questions for either Board Member Yuen or Board Member Char? No, okay. Representative Tarnas, last questions. Or either.
Questions other than Mr. Char, do you have words of wisdom that you can share with the legislature after having read the audit, listened to our questions? Any final words of wisdom that you can give to us as we try to navigate forward here?
Well, for one thing, I think if nothing else, this has been a good opportunity for this whole investigation, a good opportunity for the department to look at itself and to improve itself, and for the members to become more conversant with the issues and the potential negative aspects. So I very much appreciate this opportunity to, as a board member, to have this discussion and the opportunity to go back and speak to my fellow board members and the chair.
Well, thank you. I appreciate your insights on that. And at the appropriate time, Chair, I offer the same opportunity to Mr. Yuen to give us his words of wisdom, but at the appropriate time.
Okay, let's hold up on that. Any other questions, Rep. Kobayashi, from either of these testifiers?
No, I'm good.
Thank you. Rep. Perruso, none. Rep. Hashem, none. Okay, I actually have a quick follow-up question, and I think this is probably more appropriate for Mr. Yuen, and I just want to follow up. This is an outstanding issue. You know, we as a committee learned about an omission with the incident of a forged easement. I don't believe Mr. Char was on the board at the time. But Mr. Yuen, do you recall being apprised or briefed on any issue related to that incident regarding the forged easement on Kauai?
The only things I know about that are from reading the newspapers.
Okay, so it was brought to your attention by the media attention that was surrounding this committee's uncovering of that through looking at the omissions from the report.
Yes, I'm pretty sure that that's the only way that's the only information I have about it.
Okay, and then if I'm wrong, Mr. Char, were you on the board? Were you apprised of any of this situation?
No.
Okay. We understand as a committee that there is going to be attempts to fix that forged easement, but that's probably matters that are going to be coming before the board and it's being dealt with the attorneys. And so I'll leave it at that. But I just wanted to make sure we circled back on that loop. One other question, and maybe this is for both Mr. Char and Mr. Yuen. You know, a lot of the discussions we've had about the policies around marketing, strategic planning, rent renewals, negotiations, adjustments. It may be an issue that was discussed below the board level, and there might have been differences of opinions amongst the board or the department staff versus the department management. Has there ever been instances where individuals from the department staff have raised questions of policy that might have differed from some of the recommendations that were provided by the board management that you recall? Excuse me, can we hold? Let's go, we're gonna take a quick recess and you can think about that question, recess. Reconvening our House Investigative Committee. For the members of the public, we have a rule where we need to have quorum present. So because we had lost one member who had to step out to take an urgent family call, we needed to just recess very briefly. But I think we should be finishing up shortly. So I'll restate the question and maybe be a little bit more clear. So one of the things that we've gotten a sense of, and you know, these are policy questions that are in fact determined by the board, that sometimes there is disagreements amongst the board, the DLNR staff versus the DLNR leadership. And so questions with policy implications get elevated to the board. And I guess my question would be is, having reviewed all of the submittals and seeing the extensive briefing that board members undergo, do you get a sense that you are given enough facts, analysis, and that even if some of that analysis may conflict with the DLNR management, that you folks can diligently make decisions and consider all of the options before you, whether or not they're going to agree with DLNR management versus DLNR other staff who might have different recommendations? And I don't know if that's clearer.
Yeah, I think insofar as the land division is concerned, I'm satisfied that I'm getting information not only from the head of the division, but the staff members. Where I find there's more conflict and confusion is with the coastal land, because that's a terrible area now, and the stone walls and the replenishing beaches and things of that nature. But the one thing for me, at least, is that the staff has always been available, whether it's, in this case, Russell or people working with him, Ian, Kevin Moore, they've all been available to me. And I have in turn spoken to not only the division head, but the staff when I've had a question. I've had no problems in getting information.
Mr. Yuan.
The staff submittals almost always come with a recommendation, and that is basically vetted and signed by the division head, and then the recommendation is signed by the chair, although that doesn't mean the chair is going to necessarily vote for it when it comes through. It's being approved for submittal. It would not be, and I think if you understand, sort of basic bureaucracy, it would not be normal to put in that some member of staff, for example, an idle land agent, disagreed with the ultimate decision of the administrator. And so I wouldn't expect to see that, and you don't see that. What you do see sometimes is a discussion of pros and cons, which I appreciate. Perhaps not as much as there should be, but usually, eventually, you do get, if not in the staff submittal, in public testimony, if there are some significant reasons for against the staff submittal, you hear them from the public. I think in the internal process to come up with a recommendation, you're just not normally going to have the dissenting opinion there in your staff recommendation.
Thank you. Thank you for answering what was really a tough question. I guess what I appreciate is, after having looked at so many of these submittals, and even just a singular submittal on one issue is often pages long. And you as a board go through these submittals on each of these issues routinely in these marathon sessions that Mr. Char explained. And I guess what is interesting to me is that we've had this conversation in this committee about what is the role of the legislature in setting forth broad policies and in some ways laying down the strategic planning. And then we turn that over to the boards and the division staff, and they execute on the legislature's laws, which is what you're supposed to do. And that sometimes you folks really are the place where the rubber meets the road, and you folks are resolving those hard community-specific decisions and balancing and weighing all of those factors, whether it's preserving natural conservation lands, preserving or ensuring economic regional development areas, or promoting small business, and that you folks in the decisions that you make issue by issue are really where you grapple with those things that we can talk about at a high level and in legislate, but that you folks have actually the harder task. And so I really do appreciate some of the tough decisions that you have to make. And I have seen in the board submittals where the board has not actually followed the recommendation or voted against the recommendations of the staff. And so there is a degree of independence. I think there was a suggestion that somehow the board just rubber stamps decisions. And my experience is having talked to the board members here today, as well as the board members in ADCs, that's not what's happening. That there is actually a lot of thought that's placed into the work being done, the public volunteer work that you're doing. And I will get off my soapbox at this time, but I just really wanted to get a sense, about the work done by the board to balance all of these important needs. And so I think I did get that, and we will continue. The committee is continuing to look at the various submittals and taking a closer look also at the more problematic issue areas that were identified in the audit. With that said, thank you, Mr. Yuen. Thank you, Mr. Char. I want to leave, Chair Tarnas, did you want to ask your last question of Mr. Yuen before we wrap up the testimony?
Thank you, Chair. Yeah, Mr. Yuen, did you have any final statement, any words of wisdom you can pass on to us at this opportunity?
Well, I appreciate what the committee has done and is doing, and I appreciate there were a number of searching questions. I did want to clarify something that came up in questioning of Mr. Char, and I suppose I did not make myself sufficiently clear. And there was a discussion about sweetheart deals. I think I had talked about wanting to be assured that the RPs, the revocable permits, were not the result of favoritism. And my comments were strictly with respect to the revocable permits. When there was a major series that came out in the Star Advertiser around 2016 on the revocable permits, and there were a number of specific instances where they raised questions about people who seemed to have or possibly had political influence affecting RPs. And I looked at each of these, I really did. And each of them has a story, but I was satisfied that in none of them was somebody getting a big favor because of some political influence. We could have a separate discussion if we wanted about the leases. I think that leases operate, the lessees have influence on a policy level, which involves both the legislature and to some extent the department. But I do not think that lessees are being treated differently based on pull. On the department on a lease by lease basis. I don't think, and I really would hate to see it if it happened, that they say, for example, a lease extension is decided on the basis of who is asking for it. So I wanted to, though, to clarify that my remarks earlier on influence were on the RPs. And I look, we have a papaya packing facility that has been under RP for a long time. And the basic reason is that it's supposed to be transferred to the Department of Ag, and it's under Act 90, and it's never happened. And I don't know the reason for that, but at one time, somebody who was influential in the Waihee administration was the treasurer or something of the Papaya Packing Association. I don't think that has anything to do with our situation here in the mid, 2010 period. So that's the kind of thing that was in the story and that I tried to look into and felt that that they had explanations that were not due to somebody being treated with favoritism because they had a political connection. Words of wisdom, I think we've all seen, the DLNR has a lot of conflicting, there's a lot of different mandates and some of them come into conflict. On the land leases, we are the landlord. And we want to make more money for the state. And the tenants, I don't think expect anything unfair, but they don't, it's not in their interest to pay more money to the state. And so there is a conflict there, and it gets played out sometimes in the legislature, and it gets played out sometimes in things that happen at the board. There's really no way around it. So given we certainly try to do our best in trying to look, at least I speak for myself, and I think the other board members, in trying to look out for the public interest in this. And I also think of the land division staff does put the public interest first and has been trying to do so despite different mandates and different pressures.
Oh, right. Chair Tarnas, you're on mute.
Thank you for that perspective. I appreciate that. Thanks very much, Mr. Ewan, and thanks very much, Mr. Char. Back to you, Chair.
So if there's no other further questions, I do want to thank Mr. Char and Mr. Ewan. I think the conversation provided by the board members, the insights of the board members on the audit, as well as some of the steps being taken